Are we live?
All right, you are live.
Great. Welcome to the Civil Law Subcommittee meeting, the first Judiciary Subcommittee meeting of the year. And I am trying to open up our agenda right now. But we have 6 bills on the agenda that you received. And of those, however, only, let me see, let me just rotate this clockwise. Okay. We only have 2 bills that I think are ready for us to really vote on, but let me just go through the other ones first and just give people a rundown. House bill, and Holly, please correct me with if I'm not saying anything correctly, but House Bill 18 is the Limited Power of Attorney Act. It was Delegate Hill's bill that dealt with powers of attorney and procedural aspects to them. The Bankers Association, as well as some other folks, were very interested in an amendment that Delegate Hill was going to make sure happened. They just got the recommendations from the association that was providing it today. They need time to draft those amendments. So we're going to hold that bill for our next meeting, and we should have the amendments to everybody as well by that time. Speaking of which, we're going to try and get amendments to everybody when we get them, the bills that we're going to be dealing with on subcommittee. And if for some reason you don't have the amendments, just get in touch with me and we'll make sure we get them to you. But we're still working on details and all the intricacies of getting information to everybody timely. Okay. House Bill 129, which is Delegate Rosenberg's SLAPP suit bill, is ready for discussion. However, the civil law section of the bar asked us to hold it just for a few days so they can review and see if there needs to be any technical amendments to the bill. They're not sure there does need to be, but they wanted to ask us to do that. So out of courtesy to Delegate Rosenberg, will of course hold that bill as well. If anybody has any comments on either of those 2 bills, that's fine. I'm just letting you know that we're not gonna vote on either of them today. We do want to have a discussion on Delegate Moon's 287, and Holly and Matt, have we gotten? Do we get the folks from MACO on the line?
Matt, were you able to get in touch with them?
Bill number again?
House Bill 207. It was the three people I sent to you to send an email. Did anybody get back to you?
From MACO. Matt, are you looking to see if you got an email from them, or? Okay. For everybody, just everybody's knowledge, Matthew, you can see him on the Zoom, is my staff and is learning how to organize the Zoom as we do it. So we're learning, we're building the plane as we fly it.
Well,
Matt, did we get any response back from the MACO folks? Okay, you don't have any sound. That's part of the problem. So maybe you've answered us a couple times, but you don't have any sound.
Delegate, let's give him a minute. I can walk over and check on his computer, and then we'll come back to House Bill 207. Do you want to move on to, let's do House Bill 244, the Estates and Trust Electronic Filing Bill.
Perfect.
I'm sorry, I have a quick question. I'm sorry, I have my hand up.
Sure.
Do you have a comprehensive list? Because the list that was sent over was kind of written on. It was kind of confusing. I couldn't follow it very well. Do you have a list like a normal list?
We don't right now, but in the future, instead of sending you the list with the written notes on it, we're going to recreate that and provide it with the amendments that are available for each bill. So again, we're flying it. We're flying the plane as we're building it here today, first time. But we really only have 2 bills that we're going to be working on today anyway. And hopefully, if we can get 207, if we can get the folks from MACO to talk to us, we can maybe work on that one. Delegate Terras's States and Trust Bill, Register of Will, electronic filing and signatures. This bill, for those of you who don't remember, everybody should remember, basically allows the acceptance of papers by electronic filing by the Register of Wills in the same way that the court system allows it through MDEC. It does not change the law in terms of what has to be wet signed and what can be electronically or can be computer generated or electronically signed. It just says that when you're filing the documents with the court, you can do it electronically as opposed to having to walk in person and do it.
Did anyone oppose this?
What's that?
Did anyone oppose it?
There was no opposition. There was no written or oral opposition. And it really is, as far as I'm concerned, technical and seems to be a way to improve efficiencies. Yes, Delegate Conaway has a question.
Just to refresh my memory, did we say that the actual will has to still be wet filed?
Yeah, there's no change in the law question. There's no change in the law as to what has to be wet signature. For example, a will still will be required to be wet signature. But now you would be able, presumably, if you had a document that you're attesting to the fact that you are you're sending in your schedule or your interest worksheet to the Register of Wills or whatever documentation that they require to open up an estate, you can now file that electronically as opposed to having to walk it in and hand deliver it. So,
Thank you very much.
Yep.
Can I move the bill?
Sure. Is there a second? Oh, wait, before we, let's get a second first and then we can have more discussion. Is there a second? Okay.
I second, Mr. Chair.
Yeah, Delegate Phillips, you had a question.
So you said something, Delegate Cardin, I want to make sure that's clear. And I don't know if this is in various jurisdictions. This is an area where I do some practice.
Sure.
My understanding is that on documents, there are courts that require wet signatures on filings. You're saying that that is not a requirement.
That is not a change. This is no change to that now. In other words, if it requires a wet signature, it still is going to require a wet signature. What it may allow, and Holly, you can answer this question. Are Holly, you on? Or are you?
Yep, I'm here.
Okay. Is that if it requires a wet signature, but then can be e-filed afterwards, it would then have to be scanned and then e-filed. Great.
Yeah, that's correct.
So it still requires, so there's no change in the law in terms of what's required for wet signature. It's just a question of whether you can e-file it versus having to hand file it. Does that make sense?
Okay. So a client would come in, they would sign, lawyer would sign, would file it. In essence, the counsel is attesting to the fact that the documents were signed. There was a wet signature.
That is correct.
Okay. All right. I get it.
I would suggest the same is, there's lots of areas of business that, you require a wet signature, but still you can scan that signature in, and as opposed to just signing /S, which other areas allow for an electronic signature like that, or just to have it be a pretend electronic signature. Yes, Delegate Conaway.
Just to be clear, your quote unquote wet signature could be stored on your computer. And you're saying that the will, you could attach that signature to the will versus writing
Right.
up the will and then signing it and then scanning it individually?
I don't believe that you're allowed to do that for a will, but I mean, there are, you know.
Well, I need to know
I'm
that.
not,
I need that.
I don't believe you can do that for a will. I believe that you have to actually sign a will. You can't apply an electronic signature, which is what you're saying. I think you actually have to sign it. And that's what you're attesting to when you sign it. So I don't believe that is the fact.
So can you sign the will and then scan it and then send it in to the registered wills office under this bill?
No. I'm reading it very clearly, and Mr. Chair.
Yep.
So
Okay.
I've reviewed this one. Following electronic sign-in, we'll have the register shall accept any document except an original will. So the original will must still be filed with the court.
Right. And I don't believe that in an original will that you can attest to the fact that you are putting in an electronic signature, which is what I thought the question that you were asking. So, right. So the documents, the will has to be done. And one of the reasons why some people don't make copies of wills for legal purposes and for, so they only have one copy as opposed to just creating lots and lots of copies. So that's a good question. Yes, Delegate Arakan.
Are there any potential unintended consequences that we're not addressing? Does anybody have any idea if somehow this could end up blowing back on us?
So I think that was a question that was asked actually at the hearing. I don't remember who asked it. It might have been me, because that's really the question that we have. And the answer was from the registers of wills, 2 of them. I think there was one, my register will was testified, as well as the one from Howard County testified. They indicated that there are no unintended consequences. As far as we know, this is simply for efficiency purposes. This is not changing the requirements for wet signatures, and it's only just making it more efficient and effective for them to be able to do their job.
Okay. So we're not increasing the risk of fraud or anything like that, or
no. If I felt that way, I would be very concerned.
Right. Well, in that case, let's move favorable on it.
Yeah, it's already been moved and seconded.
Move the previous question then.
Yeah,
Right.
move it. Yeah,
Thank
exactly. Yeah.
You can either use your hand signal or you can just put your hand up. All those in favor of the favorable motion with a hand up or okay. Are there anybody opposed? Very good. Ms. Delegate Williams, you probably want to take your hand out. Great. So that passed unanimously. And of course, I do not believe that subcommittee votes are actually recorded, but it did pass. Great. Delegate Taras, I'm sure will be very happy. There's something in the chat. Let me just make sure. This was sent confusing. Yes. Yes, Delegate Tolles, it was confusing, and I agree with you, and we will work on that. Thanks for the comments.
Delegate Cardin, we have people in the waiting room. Matt, his sound is not working on his computer. I'm not sure what is up with that, so we need to work on that. But we do have Mako and
why don't we go to 207?
Perfect.
This is Delegate Moon's bill on liability. Delegate Moon, do you want to just remind everybody what the bill's about real quick?
Sure. It was basically saying that a commercial recreational facility could not have someone sign something saying they weren't responsible no matter what happened, and sort of disclaim their liability.
Such a disclaimer would be unenforceable, right?
Correct. There are 2 amendments before you. I don't know if you got them in advance. but I'm happy to explain what they are if you'd like.
I'll
So,
send those out right now, Vice Chair, but we do have them. So if Matt, if you want to screen share them, you feel free. I sent those to Matt and I'll send them to everybody in an email too right now.
okay. So we're gonna get those to everybody. Will you just explain while everybody's getting the amendments, explain why the amendments? I think that we have Mako on here now to explain what we're trying to accomplish.
Yeah, so there's one set of amendments that came from the Maryland Association for Justice after consulting with some of the stakeholders, and that clarifies the definition of recreational facility to include a swimming pool and gymnasium, I believe. And then the second aspect to that was this question about what happens when it's a county or local government entity that is running the facility. And the second part of that amendment would clarify that when the government is acting as a landlord, say to a commercial summer camp or what have you, that they would not be liable. Now, so that's the one set of amendments that I put in. There's a second set of requested amendments, and I had a nice chat with Mako and MML yesterday or the day before about what they were trying to do. And it sounded like the one bit of clarity that maybe they wanted to put before us was whether in passing such a law, we intended to go beyond the county and local government tort caps and protections. And I don't believe that was the intent of the bill, to sort of override existing government liability protections. MAJ can stop me if I'm wrong there. But if I'm not wrong, then there is language in the third clause of the Mako proposed amendment that would handle that scenario. So that's in a nutshell the two amendments.
Okay. So let's see. And I did get the amendment. Did everybody, if anybody did not get the amendments, let us know and we'll resend it to your email addresses. Questions about the amendments. So I'm looking, so one question, Emily, maybe you can help us with this.
Sure.
So if we have a gym owned by a school, would that be included in the Mako exception? A local school, a county school?
Right. So just to get back to the original language of the bill, they're couched as commercial. So I think right then and there, it wouldn't include the government gym because it's not a commercial gym. I understand.
So what about a private school gym that's not commercial?
I don't believe so. I don't, even if it's a private school gym, it's not a commercial activity. It's not, out there in the state commerce, but okay, apparently there was some concern. And so I think the most recent potential amendment was just to sort of say, if it needs to be said, that I think it is accurate to say that there is no intention, this bill did not intend to affect one way or the other the government's liability under the Local Government Tort Claims Act. In other words, people could still bring their claims, they'd still be subject to the cap. It really wasn't intended to affect the government facilities at all, and that's why the word commercial was initially included.
Okay.
So Delegate, if I can just jump in there from Mako.
Sure.
So it's not really a school gym that we would be worried about. So first of all, I want to break that down. So the use of the word commercial. So, is this meant to include a government facility? No, but there are certain things that local governments do through their rec programs that can be classified as commercial by the courts. And so that is our first red flag there. So, just a school gym, owning a school gym, would that loop us in? No, but if a parks department is performing some certain activity in a park, that can loop us in. But when we get to the amusements part, so there's three things in this. The amusements isn't classified as commercial. And again, county parks and rec do run certain things that could be classified as amusements. And so that's where most of our concern comes on that front.
And does the amendment take care of that?
We would prefer it if commercial is added in front of amusements. I think that would definitely help. But as Delegate Moon described, that most of our other concerns are taken care of with the two amendments that he brought up.
Okay.
And Mr. Chair, if I may.
Yep.
I thought an instructive example here, I don't know if Dominic would agree, but I was sort of walking through a Montgomery County ice skating rink that's run by our Parks and Rec. And under the scheme of, I would think in that scenario, if the county's renting, doing ice skating rentals and things of that nature, and they just, for whatever reason, don't run the Zamboni over the ice all day and are letting kids go up and down on the jagged ice, that there's absolutely a liability there, and that we shouldn't amend this bill to say the government too can make everyone sign something saying we're not responsible for anything that happens here. Sorry we didn't run the Zamboni, but you're out of luck. That's where the government tort cap would sort of limit the government's liability, and we wouldn't want to mess with that aspect of this. But I don't think also that we're trying to let the government completely off the hook in case they themselves are running a commercial-ish enterprise by way of the government and engaging in the same liability. So I think the two amendments sort of strike a decent balance here, and I think that's what I understood Mako agreed with.
Yeah, so Mako's position is we just want to keep the status quo. We don't want to change any way the local governments are held accountable. We just think that unintentionally we are dragged into this, and the status quo for what works right now we would like to maintain. And speaking with Delegate Moon, I think the two amendments that he brought up, clarifies that.
Okay. Can I get back then? So Mako is okay if these two amendments pass. That's my understanding. Okay.
Yeah.
Can I just get back to commercial and non-governmental? I'm thinking of Talford Hall or Gilman School. Gilman School runs a camp. Or they rent out their facilities to run a camp. As a landlord, would Gilman School, would there be any increased liability for them in this?
So, I think you're right. My son goes to Gilman School. He goes to those camps. So
that's why do you think I did that?
I have no idea what the waiver, if we signed a waiver for him to participate, what it says. But the goal of this bill is to establish that as a matter of public policy, you can still have a waiver. The waiver can include a lot of terms. It can include terms about, you're participating in a potentially dangerous activity. You acknowledge that, all of those things. This bill is limited to one little clause in those long waivers that says, if we are negligent, you may not come after us for that. You may not sue us for our own negligence. So we're just trying as a matter of public policy to make people that are negligent be able to be held accountable. Does it
change the liability for a landlord if the tenant is the one who's negligent?
No. So if the tenant, okay, you're talking about with the amendment regarding the lease.
Mm-hmm.
Okay,
Yes.
so the amendment with respect to the lease, it's my understanding was designed to address the specific testimony that was given before you a week or two ago during the initial hearing, which was if a park or another local government facility leases their property to a private entity, and then they, by virtue of entering into that lease, are not deemed commercial just because they've leased their land. it would still, if this bill is passed, prohibit the private entity that's leasing the land and having the recreational facility from having their participants sign a waiver that exculpated them from negligence.
Okay.
I hope that makes sense.
Yeah.
I mean,
I think my question can get outside of the purview of the bill to a certain extent. So I understand. I understand what you're saying.
That's
Okay. Yeah, Delegate Arakan.
Thanks for the sponsor. Can you just remind me what was the impetus of this? I mean, I'm kind of shocked to hear, you know, if the courts were actually allowing people to behave negligently, and that piece of a waiver was actually being upheld currently under the current law.
It is. So there's a case out of the now Supreme Court of Maryland in 2012-ish. It's called BJ's versus Rosen, and involved a kid who was injured in one of those kid clubs at the BJ's wholesale club, and the parents signed a waiver. He was hurt. The parents alleged through the negligence of BJ's, and the court just had to decide, are these, you know, and they said, yes, when you enter into a written contract, you can contract under Maryland law to do anything you want, except skirt the other requirements of the law, like the Local Government Tort Claims Act. So you can enter into whatever contract you want, and until the legislature says these aren't enforceable, we're going to enforce them.
Okay. All right. Thanks. That's disturbing.
Are there any other comments?
Mr. Chair.
I just want to make sure we're looking at, because I know that Delegate Williams had an issue. I just want to make sure we're looking at all the correct amendments. Delegate Moon, is it 333925/1 and /33933/523/1? Are those the two amendments?
I can't confirm the amendment numbers on the fly. Give me 1 second.
Those are the two that I sent out. So those
Okay.
are the.
Yeah,
So
and I have
those-
both of the amendments now, Mr. Chair.
Okay, good. I just want to make sure we're all looking at the same amendments when we vote on them. Delegate Moon, do you want to move favorable on the two amendments together?
Yes. And let me just make sure I have the.
Yeah, let's just make sure we're all looking at the same amendments.
Was it just emailed out?
Yep, I emailed it as we were all speaking. I can send it to you again if you
Oh, yeah,
need
I
it.
see it.
I'm
I see
sorry,
it.
we can't screen share. It's not working right this second. Matt's computer again. So this is our first
Okay.
meeting. So we're
Trying.
making it work.
Yes, this is correct.
Those are the
Okay,
ones I
the
got
first
from
one,
Chris
the
this
first one
morning.
adds recreational facility includes gymnasiums and swimming pools, and says recreational facility does not include the unit of state or local government that leases land or facilities to a recreational facility. So that's amendment number 1. Amendment number 2 says this section may not be interpreted to affect, extend, or limit the liability of a commercial entity for a tort or other claim subject to Title 12, Subtitle 1 of the state government article, or Subtitle 3 of this article, those are the two amendments. And Delegate Moon, do you want to move favorable on those amendments?
I would like to move those amendments favorably. Yes, thank you.
Is there a second?
I'll second.
Second.
Great. Any more discussion on the two amendments? All right, all those in favor of the amendments, raise your hand or put your hand up. And is there anybody opposed? Let's just make sure nobody is opposed. There may be some, oh, there's one opposed. No? We may have had one opposed, but they're not recorded anyway, so the amendment passes.
Just raising as a pass. Sorry about that, Gordon.
No problem. Okay. Is there a motion on the bill as amended, Delegate Moon?
I'll move the bill.
Okay,
Second.
Any other discussion on this bill? Great. All those in favor of the favorable report, raise your hand. Is there anybody, okay, you can lower, anybody opposed? Okay.
I'm
And
for, not opposed, sorry.
okay, and is there anybody who's abstaining? You can't abstain on the floor, but I know in the committee, but you certainly can abstain here if you need to, unless I tell you you're not allowed to. That's really
What's that
democratic.
rule? What's that rule you just said?
I'm
I think
teasing
just
you.
made it up.
I'm teasing you, Delegate Conaway. Okay.
Mr. Chair,
Yes.
I hate to be a pest here. I just want to flag one thing before this thing goes to judiciary, which is that Delegates Buckle and Tolles had asked for a co-sponsor amendment on this bill. And I believe the rule last year was if we're already changing the bill, we can do that. So I just want to flag it now
Right.
so I
Well,
don't get in trouble.
thank you. I'm going to give,
Me too, add me.
Holly has to say that she's willing to do the amendment, but is there anybody else on the subcommittee that would like to be added to the bill if we can get a sponsor amendment?
So I'm getting word from Dylan. This can be added during the actual vote session when we vote as committee. So we're not going to amend it any farther until then, but then everybody can jump on. So as long as it's already a bill that's been amended, we're going to allow it just like last year.
Awesome. All right. So I believe that this has passed and we can give a favorable report to the committee. We have one bill left to discuss, and that is House Bill 215, which is Delegate Pakovich Carr. Thank you. I'm sorry, you know me, I'm terrible at pronunciation. And this is on Holly, can you remind us what the bill does again? I'm going to pull it up.
Let me pull it up. Pulling it up. Hold on.
I just don't want to misspeak because I remember the bill. I love the bill.
Yeah, this is one that we passed out of the House last session, 95-42. And you just bring it up. It does a few
The
things.
bill creates a presumption that a local law or ordinance related to summoning law enforcement or emergency services to a residential property is prohibited if it authorizes or requires, one, the assessment of a monetary penalty or fine on an owner, or two, the use of an action for repossession of a dwelling unit from a tenant or termination or non-renewal of a tenant lease, or three, the revocation, suspension, or non-renewal of a rental license.
I'm sorry, I'm thinking of the wrong bill. What's the bill number?
It is 215.
Thank you.
Mr. Chair,
Yes.
just so I understand this one in plain English, was that the purpose of this was to stop you from getting in trouble for calling 911 for help? Was that the idea? Something
Yes,
like that?
that's exactly right.
Okay. And what was the vote?
Last year?
Yeah.
Holly?
The vote on the floor was 95-42, and the bill is introduced as it was amended last year. So it includes additional exceptions. It added mobile crisis team. It added provisions, for example, like it didn't apply to parking enforcement, calls to law enforcement concerning social gatherings with certain noise levels. The bill is introduced with all of those changes that we made last session.
Right. And was it partisan? Was the vote partisan? I just want to be clear and
Yes.
Okay.
Well, sometimes they get confused on the floor, though. Was the committee vote partisan?
Hold on, let me check.
I swear to God, it does seem like sometimes we get R's in committee, and then by the time it gets to the floor, people get confused and vote against it.
I agree. That's a good question. Basically, if you are calling 911, you can have clauses in your contract that cause penalties against you for calling 911, and we're trying to basically make those clauses unenforceable. Limits the ability of a tenant so the bill prohibits the landlord from including provisions in a lease that limit the ability of the tenant to summon law enforcement, call 911, or to penalize the tenant for actions solely because the individual summons these law enforcement services. So if they can still get in trouble if they're doing something that is they're harassing, they are doing it without any real reason to summons, those are okay, but you can't do it just because you're calling law enforcement.
And I have the vote. It was 14-6. One was excused, and it was a partisan vote for the committee.
Sorry, can you say that one more time?
Sorry, it was 14-6. Was partisan. One was excused, listed down as excused, but 14-6, and it was a partisan vote.
Yes, Delegate Arikan.
I'll just explain why the Republicans did not vote for it.
Absolutely.
We felt concerned because currently this law as it stands is so that if a tenant repeatedly has the police called on them, that the landlord has the ability to maintain the status and quality of the property and of the neighborhood by terminating the lease with someone who continuously has the police arriving at their home, because it degrades the community. And the idea behind that is that the people are engaging in some kind of repeated illegal activities, whether or not they get charged for it or not. Other people in neighborhoods do detest having repeated calls to police over and over again to the homes. It's unnerving, and it does degrade the community. So that's why I think many Republicans chose not to vote for this bill, because we do think landlords should be able to say, this home has way too much police activity, and we need to find a tenant who's better suited for this community, who's not engaging in activities that require repeated police interaction.
Right, but can I just comment on that? It's the person calling, not the person receiving the police, that can be terminated according to the bill.
I think it's both. I think I think right now, the way the law is written, the landlord has an out for, whatever is needed if the home is repeatedly frequented by law enforcement. And so the thought was that the way the bill is written and the way it hit the floor on second reader was a way that would have prevented a landlord from being able to say, there's just too much going on at this house, and it's degrading the community.
Okay, any other thoughts or comments?
Mr. Chair.
Yep.
I understand that concern. It's all coming back to me now, and I think we had a pretty robust discussion the last couple of years on, what type of nuisance warrants, landlords being able to get out from under their lease, and I think everyone was very sympathetic to that. But I will just remind people of the two other scenarios where I think this bill is intended to clarify things. A domestic violence survivor who may have quite good reason, and maybe they have someone crazy coming by their house here and then. It's just not, you don't want them to be deterred from summoning help because they might jeopardize their lease. And the other one, and I'll tell you this one from personal experience with family with behavioral health issues, is that I do think there has to be at least some sort of recognition of disability accommodations with people's housing. They're already, people with those conditions are often in a tenuous housing situation to begin with. And again, believe me, if you have behavioral health issues in the family, the last thing you want to do is call 911. We already are disincentivized from using it for many other reasons, but I don't think the housing should be one of the things that contributes also. That's all I'll say.
Delegate Arikan.
I would just say, I feel like there's a way for us, because I agree, if somebody's a domestic violence victim, if they're the victim of stalking, anything like that, then obviously it should not trigger this. So there may be a way for us to craft it if we wanted to get down into the weeds, so that we could specifically lay out instances where, if they are on a domestic violence call, that's fine. If they're there for certain medical reasons, that's totally different.
But all right. And
You know, there may be a way to craft it if we want to go down that road, or, you know, you can move it like it was last year and it'll just be a partisan vote. It's up to you guys, but, you know, if we want, we can make this a bill that we really dig into, but it's
so
up to
I
you
would,
guys.
I'm gonna ask that we move the bill today, but I'm more than happy to, if you want to let the Senate know, to try and craft amendments and comes back on in a conference, and maybe we could even recommend you be on that conference to get the bill passed with those amendments, who knows? But I will say though, that the way I read it, it's only if it's the only like there can be other reasons that a landlord can dismiss a tenant. But if it can't be solely for the purpose of, for the reason of 911 calls. That's the way I read the bill. In other words, it can be one of a couple of 2 or more reasons, but it can't be the sole reason for the dismissal. Is that correct, Holly? Do you know?
Yes, that's what it looks like, but I mean, I'm happy to look at it more.
No, I mean, that's the way that it was presented. I'm just going to look at language real fast.
That's how I'm reading it also. I mean, obviously, if the police is called and the tenant is engaging in some type of illegal behavior, I know it's very common for a lot of leases to have in their lease agreement, you know, if the tenant is engaging in illegal behavior, the landlord can terminate the lease. That would still stand. And I think that kind of gets to maybe your concern, Delegate Erican.
I think that would require conviction. My concern is page 3, lines 1 through 3. I think those were the
right. But it says solely because penalizes a tenant the actions of another individual solely because the individual summons the assistance of law enforcement.
Right. So a neighbor calls law enforcement repeatedly because somebody's doing something in that home. This language here would say, you know, as a landlord, if one of my neighbors continues to call the police because they see illegal activity or they think they do, even without conviction, as a landlord, I can say, look, this tenant has become a problem. The neighbors continue to have to call the police on them. I'd like to terminate my lease with them. If you guys want to strike that language, and it's only if the person is calling for help. So like, if my tenant is calling for help, that's totally different. But this is like third parties continuously calling or being removed.
So I'll just say one more thing, and then we can maybe move the bill. But if somebody is charged with, if they're not being charged with anything improper at all, then, and there is no illegal activity going on there, then I think that your issue is answered. But if there is in fact illegal activity, but there's no conviction, you can bet your bottom dollar that the police are going to get something on the record, charges or some kind of impact, police report, whatever, that can then be used as a secondary grounds, not just the calling of the police.
Yeah.
So that would be my comment. Delegate Williams, did you have a comment?
Yeah, I was just going to add my only concern with what you've proposed, Delegate Erican. What if it's my husband's name who's on the lease? My name as his wife is not on the lease, but I'm the one calling the police because he's beating my butt every single night. You see what I'm saying? I'm not the technically I'm not the tenant because I'm not the person on the lease. I just simply reside there, but I'm the one who's calling the police because I'm the victim.
Yeah, I hear that. I'm not sure if tenant is defined as the person whose name is just on the lease, and it does not include people who are residing on the property. I would assume, we can look it up. It's probably somewhere else in the code, but I would assume that tenant includes anyone who's legally residing on the premises. That's my guess. But if not, then perhaps we should fix that, because yeah, if in that scenario, I would never want someone to be penalized. Obviously, that would be horrible.
Yeah, I mean, because the other scenario, whereas you're on the lease, your husband is not, somebody else calls because they are concerned that your husband is hurting you, and now, you know, those are, I mean, you can come up with lots of different hypotheticals, so.
Mr. Chair,
Yes,
very briefly, and thank you. So just keep this in mind. At one point in time, someone thought it was wise to put it in the law, put in this provision for these chronic, for these kind of situations. Like, this is a situation where you're in a unit, police are continually called, and at some point, someone thought it was valid to make this to govern these kind of situations for quality of life, for the quality of life for the people living there. I mean, they came to the legislature to put this in place at one point. And these are situations that govern it when police are called. Now, that there may not be a criminal penalty, there may be a charge, but not a conviction. But
yeah, I mean, you make a very interesting point. I'll only say, how do you know who came to the legislature to get this bill put in? Was it, in fact, people that wanted a better quality of life? Or was it the landlords that wanted to be able to evict people more easily? I mean, you don't know.
Yeah, the point I want to make here is that I think, I like the bill sponsor. I just think, like, we should look at the bill file. We have massive quality of life problems, especially around apartment complexes. And I like, this is a very narrow remedy. And if this goes forward, you're going to have property owners who are saying, holy crap, we have these terrible toxic situations. I have no remedy. And people are going to use, anyone could just not, they could just hold over and say, look, I'm using this as a defense. So I sense that we all sense that there's a little bit of a hole in the law here. It probably should be closed to govern cases where there's a legitimate public safety or a health concern. But you're completely removing this quality of life remedy that is legitimate. But thank you.
Delegate Conaway.
Yes, Delegate Grandma, are you suggesting that you'd like to hold the bill?
No, not at this time, Delegate.
Thank you very much. Thank you very much.
All right, I'd like to move the bill.
Is there a second? Are you seconding it, Delegate Conaway? Or no?
Yes.
Okay. Any further discussion? All those in favor of the bill, can you raise your hand, please? 1, 2, 3, 4, 5, 6. Okay, all those opposed? 1, 2, 3. And Delegate Schmidt, I don't know whether you're for or against.
Roll call. Because I can't see who's for and who's against.
Delegate Schmidt is, well, we had 3 opposed. We don't take roll calls, and I mean,
yeah, we do.
we don't record them. We had 6 in favor, 3 opposed, and we're not sure where Delegate Schmidt is. He's probably not paying attention. Okay, the bill passes, and we're done. Is there any, Delegate Arcand, we can talk about an amendment if you want and get it over to the Senate. Is it cross-filed? Okay, we can look and see. All right, any other comments for the good of the group? It was a good first effort. Hopefully, Delegate Moon, you'll do a better job with the technology in your first subcommittee meeting. And Delegate Williams, you too. All right, motion to adjourn.
So
Okay,
moved.
second. We're adjourned. Great, thanks.